Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the Court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
Thank you. Thank you. Some reasonable logic from this judge. Good job.
Judge did inform counsel that the jury was at an impasse, and I would argue at this point it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again,
but as the prosecution, they should also want to get down to the results of each count. As the prosecution, they should also want to know what the result was for each count. As the prosecution, they should be careful and cautious, right? Like the language reads, careful consideration to alternatives, and no alternatives were provided. No alternatives were executed.
Just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
rather than speculate what the defense wanted. Let me ask you about what happened. Did the judge have either the discretion?
It's strategic for the prosecution to bring up the crime in the first place when nowhere in any of the filings is the crime mentioned, other than the backstory, okay, which the defense provides and the prosecution provides. They provide the backstory, right? This is what Karen Reed was accused of, but that's it. What is being argued on this court day with the Supreme Court, what is being argued are the three requests made by the defense in their motion to dismiss. The fact that the prosecution brings up what Karen Reed is accused of, and then he uses the word she was allegedly framed, it's like, what is that? He did not need to bring that up to make a point. It's as if rubbing it in Karen Reed's face or rubbing it in the judges' faces, like as if to taint her badly. I'm just saying, like, there was no need for him to bring that up as an example. It seemed deliberate. It seemed strategic.
Discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues...
So it's not inherently coercive?
Even the prosecution is lying. This dude, new to the game here, putting on his prosecution uniform. Even he is lying. Even he is lying about what Rule 27B actually reads. The word may is in there as permissive. Someone may do this. It is permission. The judge may declare a mistrial, but she must first require. The word require is in there. But notice how these judges and the prosecution completely overlook the word require in Rule 27B. The word is require. She must first require the jury to return verdicts they do agree on. Just liars, you know? Just fucking liars. I swear. I bet the prosecution uses Rule 27B when it works in their favor. But when it clearly doesn't work in their favor, they selectively ignore it, including the very language that is written in it. The word require. Just overlook it because in the beginning of the sentence is the word may. Right? Ignore all the steps to declaring a mistrial. Just completely throw all those steps out the fucking window like Rule 27B doesn't matter. Right? It's just there. It's just there for show. The rules of criminal procedure are there for show. They don't mean anything. When there are multiple counts against a defendant, it's perfectly reasonable to exit the trial with ambiguous verdicts. Yeah. Right? Rule 27B doesn't fucking matter, right?
If the judge has the discretion, it can't be coercive, correct?
No, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion, and that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It would be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why wouldn't we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse, there is a manifest necessity for a mistrial, there is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent.
It's, the response so far from the prosecution is expected. The shit coming out of this guy's mouth is not surprising. Just very smooth, right? Listen to how he just smooths it all over. Consistently defending Judge Bev, just like Adam Lally defended her, Michael Morrissey defended her, and he's very smooth about it, running one sentence into the next, like, to me, feigning confidence, feigning like, I'm correct, Your Honor, and I'm confidently correct. He's full of shit when you consider what he's actually saying.
It's out the window, isn't it?
I don't agree, Your Honor.
Really?
Consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two notes. And what was the defendant's response to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so,
Thank you. Thank you. As the camera zooms into Karen Reed's parents, thank you. Just because they wanted the Tui Rodriguez instruction doesn't mean they wanted a mistrial. Boom. Completely countering what Judge Beverly Cannoni said in her own court filing. Judge Beverly Cannoni said in her own court filing that because the defense knew and asked for the Tui Rodriguez instruction that they should have expected a mistrial. And she said that completely out of her fucking ass. Again, taking zero responsibility for what happened that day. And for the prosecution to even bring up how just now, today in that Supreme Court hearing, like for the prosecution to bring up how the jury had an exhaustive 10 weeks. Yeah, but you say that now, dude, but you won't listen to them after the trial. Like, how are you going to talk about how exhaustive this was for the jury while you also ignore them? You ignore their verdicts. You make all of their efforts all for naught. Right? Like, it was futile. The whole deliberation process that took place in the Karen Reed case was futile because it's clear that Judge Beverly Cannoni and the prosecution had zero intention of having those verdicts read in open court. That is why they persist in defending one another.
They had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room, and even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room, and at that point the judge did still consider counsel's arguments. And I think, given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan. Mm-hmm. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue.
Because TUI, there's two results of TUI. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the Tui Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as...
Brilliant. Thank you. Brilliant. And yeah, these judges are being objective here with what I consider are shitty arguments from the prosecution, shitty arguments that are not accurate to what happened. They're not accurately applicable to what happened. The prosecution, again, is just defending Judge Beverly Cannoni. but I still say that the way in which the judges responded to Martin Weinberg, Karen Reed's attorney, I still say it's not good. I say the way in which the judges responded to Martin Weinberg, treating this as if it would have to be new case law, or treating this, repeatedly saying that it would be going into the jury deliberations, making Martin Weinberg repeat himself in various ways to assure them that it would not be going into the jury deliberations. Like, it's all of that was just is discouraging to me. Again, I'm convinced that at least 3 judges made up their minds, and we will probably see that when we find out the outcome. But I give them credit for at least calling the prosecution out on conflating a Tui Rodriguez instruction with a desire for a mistrial, or conflating a Tui Rodriguez instruction with an alternative, which actually one of these judges did during the defense's oral arguments. The female judge did conflate the Tui Rodriguez instruction with as an alternative. And it's not an alternative. Even this judge speaking, this male judge who is speaking, refers to the Tui Rodriguez instruction as a push to the jury.
Just Tui Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations. But counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time. Let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, "We believe there's been sufficient time." Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor. There was manifest necessity for the declaration of a mistrial here.
And so absent the consent, you can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed.
Well, but counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of.
All of these judges, all of them refer to 27B, and they hang their hats on the word may without reading the entirety of Rule 27B. Every single one of these fucking judges. Again, how the hell did they make it to the Appellate Court? All of them got to go back to law school. As I've said, this case, the Karen Reed case, needs to be studied by law schools for the next 100 years because not only because of the law enforcement corruption, the cover-up that it was, right? The lack of intervention from the FBI, during the prosecution of Karen Reed, but now the Appellate Court's incorrect interpretation of Rule 27B. It's like they're so lazy. They're lazy readers. They don't even want to finish the rest of the rule. They want to stop where it says may, and they want to ignore where it says require.
Declaring a mistrial is there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this, and perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is...
She can do no wrong. Judge Beverly can do no wrong. Judge Beverly Cannoni, she was immaculate when she declared a mistrial. She was flawless when she declared that mistrial. That's what the prosecution has said in their filings, and that's what the prosecution is saying to the Supreme Court.
Some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs, but did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray v. Commonwealth, where this court said or noted there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts, and it's not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. But then the problem comes when we get this new information that's somewhat inconsistent with that the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have...
Good control of the courtroom, this judge. You see how the prosecution attempted to stir the attention away? He's like, yeah, I'm going to answer your question, but first I want to present this bullshit argument to you and tell you how there were no verdicts, right? Judge Beverly Cannoni did no wrong, and also there were no verdicts, even though post-trial Judge Beverly Cannoni considers that there were verdicts and those verdicts were true and accurate. You see how not even the prosecution can keep the argument straight without contradicting itself? That's how you know someone is completely and utterly full of shit. Just constantly contradicting themselves. That's the prosecution.
Some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
the judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability.
Exactly. Exactly, prosecution. Judge Bev said those verdicts are true and accurate. She didn't say, I'm not even going to consider them. No, as corrupt as her ass is, she actually said in her own written filing that is publicly available for all eternity, she said those verdicts were true and accurate, prosecution. But you leave that out in your fucking argument?
And then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
I just want to say I'm digging Alan Jackson's beard thing he's doing. He's growing it out. He's rocking it. Good job, dude.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their deliberations.
Well, that's a separate matter. You said that, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one...
under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a verdict that was never
What
returned.
Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right.
All right. Yep. She's got a few brownie points. I still don't like how she handled Martin Weinberg. Yeah, I didn't like that one bit, but she got a very few brownie points for being rather objective here and really getting down to what the prosecution is saying.
Your Honor, but although it is different than the Sixth in that here there's, a balance of 2 competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an
Wow. I would have never expected her to utter those words.
Interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations, and I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've sent back jurors on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's
our post-verdict inquiry is guided and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is, did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take your Honor's point.
However they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
but we asked, have you reached a verdict? That in and of itself is a standard question, right? That can't.
Oh, the prosecutions are assholes. The prosecution people are assholes. Like, it's an artificial question to ask what a verdict was? Like, mind blown, you know? It's like that atomic bomb scene. Like, that's me right now.
Be crossing the line, right? Or is it?
No, again, I want to re-emphasize the point that was raised earlier, which is, imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say.
Is that what Justice George asked?
This is so ridiculous that it's so ridiculous that Judge Beverly Cannoni can consider those verdicts true and accurate, right? That there were verdicts true, and they were true and accurate. Counts 1 and 3, not guilty, true and accurate, right? But the prosecution will defend Judge Beverly Cannoni. They will defend her. They have been defending her. They've been saying she was flawless when she declared a mistrial. She made no error when she declared a mistrial, right? But they defend her, but they also ignore what she fucking said in her own court filing. And that she even determined that there were verdicts, and all that the defense is asking is to have those verdicts recorded on the record. Have those verdicts recorded in open court, because that's exactly what Judge Beverly Cannoni is saying would make them actual verdicts, is if they're announced in open court, right? So the defense is saying, well, let's announce them in open court. And the prosecution has been stonewalling. They've been like just fighting for the sake of fighting. Like, we will not hear those jury members, Judge. We will not. It will, they will not be able to understand the simple question that we are asking, Your Honor. And it would keep them from explaining themselves, which they will want to explain themselves, Your Honor. Like, now you give a shit about the jury members' prosecution. Now you give a shit about them. Now you're concerned about them not being able to explain themselves. They've been trying to explain themselves this entire time, and you have been ignoring them, prosecution.
Your brother counsel about Bluford. Is Bluford the answer for you? That's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser includeds that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
I would argue that it is, and I actually take it one step farther, which is, not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Is Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal-first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do, and it wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short-circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants, too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote, and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Wow, a rather weak ending from the prosecution. Just like, rah, rah. Like, yeah, all right. Obviously, I would grant the dismissal that the defense is asking for, and I would completely ignore the shit arguments that the prosecution provided. They were shit arguments. But as I said, I am of the opinion that at least 3 of these judges have already made up their minds about, and it could be that they don't agree with the defense and they don't agree with the prosecution. They may make their own determination based on what the ACLUM had to say. Who knows, right? The ACLUM does not have an official role in this case, but the ACLUM statements, their amicus brief, could be helpful, at least when it comes to getting those jury verdicts heard on the record. There is still hope here. There's still hope here, but I'm saying I'm not convinced that the defense is going to get what they asked for. I feel that at least 3 judges on this panel showed their true colors immediately. As soon as oral arguments began, they showed their true colors. They showed their stance immediately. In my opinion, too soon. But we will see. We will see how it turns out. Thank you for watching.